Hello everyone, my topic is right to constitutional remedies. So as we all know that there are several rights given to Indian citizens, but merely giving rights is not enough. There must be a mechanism to check in case of violation of any of the right that the right can be restored properly. So we will study about right to constitutional remedies. Article 32. It is one of the fundamental rights mentioned in Part 3 of the Indian Constitution. This article deals with right to constitutional remedies or affirms the right to move the Supreme Court by appropriate proceedings for the enforcement of fundamental rights. Under this article, Supreme Court can issue writs for enforcement of any rights conferred by this part. Dr. B.R. Ambedkar called this article as heart and soul of Indian Constitution. He also called this article as the most important one and without which the Constitution would be a nullity. Article 226. This article is as follows: notwithstanding anything in Article 32, every High Court shall have power throughout its jurisdiction to issue writs for enforcement of any of the rights conferred by Part 3 and for any other purpose. The scope of Article 226 is much wider than Article 32 as it confers power to the High Courts to issue orders, directions, and writs not only for the enforcement of fundamental rights but also for the enforcement of legal rights. And Article 226 is a constitutional right. So, writs. Writ is basically a written order having command of the court to another person or authority by which such person has to act or abstain from doing a certain activity. A writ petition is generally filed in case of violation of fundamental rights or injustice served to society. So, writs are filed in case to help citizens protect their fundamental rights against court orders, to make sure justice is served, not denied, to offer alternatives to aggrieved party in case justice is not done by the other authorities of legal system. Types of writ: habeas corpus, mandamus, quo warranto, prohibition, and certiorari. Habeas corpus is one of the most important writs for personal liberty, which says you have the body. The main purpose of this writ is to seek relief from the unwanted detention of an individual. It is for the protection of individuals from being harmed by administrative system, and it is for safeguarding the freedom of individuals against arbitrary state action. In case of ADM Jabalpur versus Shivkant Shukla, which is also known as habeas corpus case, it was held that the writ of habeas corpus cannot be suspended even during the emergency. The first case of habeas corpus was that in Kerala, where it was filed by the victim's father, as the victim P. Rajan, who was a college student, was arrested by the Kerala police and being unable to bear the torture, he died in the police custody. So his father filed a writ of habeas corpus and it was proved that he died in police custody. Quo warranto. This means by what means. This writ is invoked in cases of public offices and it is issued to restrain persons from acting in public office to which he is not entitled to. Appointment to public office can be challenged by any person irrespective of the fact whether his fundamental right or any legal right has been infringed or not. In case of Ashok Pandey versus Mayawati, the writ of quo warranto was refused against Miss Mayawati and other ministers of her cabinet, even though they were Rajya Sabha members. Mandamus means we command. This writ is issued for the correct performance of mandatory and purely ministerial duties and is issued by a superior court to a lower court or government officer. However, this writ cannot be issued against President and the governor. The person applying for mandamus must be sure that he has the legal right to compel the opponent to do or refrain from doing something. In case of Manjula Majuri versus Director of Public Instruction, the publisher of a book had applied for the writ of mandamus against the Director of Public Instruction for inclusion of his book in the list of books which were approved as textbooks in school. But the writ was not allowed as the matter was completely within the discretion of DIP and he was not bound to approve the book. Certiory means to be certified. It is issued to seek a judicial review or of decision of a lower court or government agency. The writ can be moved to higher court like the High Court or Supreme Court by the affected party. In Surya Devi Rai versus Ramcharan Rai and others, the Supreme Court has explained the meaning, ambit, and scope of the writ of certiorari. Then, in the case of T.S. Basappa versus T. Nagappa, it was held by the constitutional bench that certiorari may be and is generally granted when the court has acted without jurisdiction or in excess of its jurisdiction. Prohibition. It is a writ directing to lower court to stop doing something which the law prohibits it from doing. Its main purpose is to prevent an inferior court from exceeding its jurisdiction or from acting contrary to the rules of natural justice. It is issued to a lower or subordinate court by the superior court in order to refrain it from doing something which it is not supposed to do. In case of East India Commercial Limited versus Collector of Customs, a writ of prohibition passed directing an inferior court tribunal prohibiting it from continuing with the proceedings on the ground that the proceeding is without or in excess of jurisdiction or in contradiction with laws of the land, statutes, or otherwise. So these are the 5 writs which we have in our constitution. And thank you so much.